Good evening, everyone. My name is Elcia Vasquez. For those of you that are new to Palantes Harlem's webinars that we've been having, I'm the executive director of the organization, and I want to welcome everyone to tonight's webinar. Happy Friday, as I like to say, first thing on Friday, all the way to the end of day on Fridays. And I wanted to thank everyone for taking the time to join us today for this very, very important webinar. I mean, as an organization, we have been doing a lot during the pandemic. As most of you that joined us for our previous calls, you guys know that we've been very active in terms of assisting families that have food insecurity relief. We also been helping families with masks, with PPEs, and we've also been providing Manhattan residents with COVID-19 rent relief grants of totaling $1,000 to help cushion the rents. Those grants are being made available exclusively to residents that live in Manhattan. And the reason for that is because the funds that we received, which are private funds, are restricted. And we're only allowed to provide these grants to residents that live in Manhattan, specifically the ones that live from Morningside all the way to Washington Heights, East Harlem, and Central Harlem. But you know, to date, we've been having a lot of families reach out to our organization for help. And for those folks that have not been able to apply for our COVID rent relief grant, we have been assisting everyone with applying to the state for the application that the governor put out for rent relief, as well as helping residents apply through the city for what's called a one-shot deal. So if you find yourself in a situation that you are behind in your rent and you need to apply for rent relief, feel free to give us a call or send us an email. At the end of this presentation, we're going to provide you guys specific phone numbers and email addresses to call and visit, and websites as well. So with that being said, though, I think, you know, for everyone on the call, feel free to reach out to us. While our office is still not open, we are taking calls daily from 10:30 all the way to 9 p.m. every day, Monday through Saturday. And you know, tonight we're going to focus on a lot of things. So I'm not going to speak a lot. I'm actually going to pass this over to our strategic partner, Jesse Gribben, who's really going to be able to provide you guys a lot of information, and also bring you guys up to speed with what's happening in housing court. There's a lot going on. Every day things change, right, Jesse?
Every day.
Every day, yeah, every day. But you know, we were very grateful to have someone like Jesse join us and donate his time to us, so that we can get this, you know, all this knowledge passed over to our clients, so that you guys can stay, you know, remain in your homes. That being said, I would like to just pass over the webinar to Jesse Gribben. Jesse, again, thank you so much. We are extremely humbled and grateful to having you, as well as the rest of your law firm, on board. And congratulations again on that huge win.
Thank you.
We might want to tell everybody. Let's get everybody excited.
I will tell everybody. Yes. Hi.
Yeah.
Good evening, everybody. My name is Jesse Gribben, and I'm with the law firm of Himmelstein, McConnell, Gribben, Donahue, and Joseph. I want to thank Palante and Elcia for inviting me to participate in this webinar. I've collaborated with Palante Harlem now for many years, as have other partners and folks with my firm. We are solely a tenants' rights firm. That's what we do. We represent New York City tenants. And before I sort of fill everybody in briefly, and I want to make sure my remarks are brief, and I want to sort of answer folks' questions and see where people are and sort of get people information. But I do want to, for a second, brag a little bit about an accomplishment of our firm. We just settled a class action lawsuit on behalf of a tenants association of a building on the east side. The litigation went on for about 10 years, almost 10 years, and we fought every step of the way, and we just settled, and the tenants in that building will be getting damages in the aggregate of $8 million in rent overcharge damages. So it's a tremendous victory for these folks, this tenants association, but more broadly for tenants throughout the city. That's certainly something that our firm focuses on, and that's making sure that landlords who violate the law and rip tenants off by charging them illegal inflated rents pay. And that's what we did, and we did that here, and it was a tremendous victory and a tremendous amount of money into the hands of these deserving tenants. So let me just sort of switch gears now and focus a little bit about sort of what's going on, sort of today as we sort of turn the page in August into September. I think, as folks know, the governor has issued a series of executive orders which have impacted residential housing in New York City and have also impacted how the New York City Housing Court operates and has operated. And both of those things go hand in hand and are related. And in another way, both of those things are both independent. So let me start with the latest executive order as it pertains to residential evictions. And that order, which was signed earlier this month, extended what is called an eviction moratorium through October 1st. So what does that mean, though? What that means is that no residential tenant in the city can be evicted before October 1st. That does not mean, though, that landlords cannot initiate housing court proceedings, right? So those are two very different things. Landlords can now initiate housing court proceedings, meaning if tenants are behind on the rent, right, due to COVID or otherwise, or if the landlord brings what's called a holdover action. A holdover action is different than a non-payment case. There's two types of cases landlords can bring in housing court. A holdover action has to do with regaining possession of the apartment, while a non-payment case has to do with owed rent. Currently, landlords in the city can initiate cases in housing court for both non-payment and for holdovers. And we've seen, it hasn't been the avalanche that we anticipated, but we have steadily seen an uptick in the number of cases that landlords are filing. So here's what I want to sort of talk a little bit about for folks that, and just to be clear, right? So the October 1st eviction moratorium doesn't mean for anybody who hasn't been sued by their landlord, right? Anybody who hasn't yet been to court with their landlord, that the landlord can come in October 1st and start evicting people. What the landlord can do is start a case. And what we're seeing now is that landlords are beginning to bring more cases. And I want to talk a little bit about what that looks like. So when a landlord initiates a case in housing court against a tenant now in the COVID era, that notice of petition and petition, that's the commencement documents for a housing court case. Those pre-COVID, those would have instructions for the non-payment to go to the courthouse, right? In Manhattan, it'd be 111 Center Street, or the Harlem Justice Center, in the Bronx on Grand Concourse, in Brooklyn on Livingston Street, etc. To go to the court, physically go to the courthouse to answer that non-payment case. No longer. Now, when folks get served a petition, it should have instructions to call the clerk's office so that you can answer via phone, and you will be given a court date, and I am told somewhere between 6 and 8 weeks later. So that's important, right? So nobody who is sued now should put themselves at risk by either getting on the train or traveling to a courthouse to answer a non-payment petition. Rather, if you're served with a non-payment petition, you should reach out to LCA, right? But you should also call the clerk's office and answer by phone. And I want to talk a little bit about the answer and what people can assert as defenses very quickly in a second. For holdover petitions, right, those are nothing to do with the rent, right? Although the rent can be part of it, they really have to do with the landlord saying that the tenant, the person that's living there, has no right to be there anymore. And those cases normally pre-COVID would have a court date on them. So a date that the tenant would have to physically go to court for that first court date. No more. Now, what the petition will have is the same instructions to call the clerks and to then answer by phone. So that's very important. Again, nobody should be traveling to a courthouse to answer these petitions, but nobody should also be ignoring these petitions, right? These court papers if you're served. You should follow the instructions, which is to call the clerk's office. What you should also do is avail yourself of whatever legal services are available, right? There is a right to counsel now. It encompasses many zip codes. We can get folks that information on which zip codes are included. Legal services offices are fully staffed. And my understanding is that there's a renewed sort of focus on being inclusive and taking cases. So I strongly encourage folks to reach out and avail yourselves of legal service. I'm a former legal services lawyer myself. My firm, we partner with lots of legal services and other organizations. They do wonderful work. Nobody should feel that because it's a free lawyer that they're not good lawyers. The opposite. They really are good lawyers and they know what they're doing. So folks should do that. Okay. One more point about housing courts. I'll just say this. We heard this week from a judge, and I can't say which judge, that there will be no conferences, in-person conferences in housing court this year, right? So that they will not be having folks into court physically for conferences. Trials could be another thing, but I don't think any case started now would have a trial this year anyway. But it gives folks, I think, some amount of insight into the process and how long it may take, right? Landlords and so what, right? They're very, very frustrated. The real estate industry is like, apoplectic, if you will, about the delays in housing court and ranting and raving about how housing court has ceased to function, which to some extent has to do with advocacy, by Palante and others and legal services providers, right? Really advocating and saying that it's just simply not safe to have thousands of tenants crowded into hallways and courtrooms in the midst of a pandemic. And thankfully, those pleas were listened to some extent, and the courts now are not requiring people to attend in person, and they're not requiring people to show up physically in the court. They might schedule something remotely by conference, but those, I'm not 100% sure if they're even doing those for folks that are self-represented, and I'll find that out. But the last I heard that they were not doing virtual court conferences, but for unrepresented pro se litigants. Okay, so the answer, right? If you're served with court papers, your answer, and this is important, right? So the first thing that folks should understand is simply because the landlord says you owe money, right, doesn't mean that you necessarily owe money. I opened by bragging, if you will, about this rent overcharge victory. And oftentimes, right, when landlords sue a tenant, it provides an opportunity for the tenant to investigate a little bit about the history of their apartment. So one thing folks would want to do is to get in touch with the DHCR and get their rent registration histories and send those to a lawyer, send those to Palante so they can analyze whether or not there's a potential rent overcharge claim, right? Maybe the landlord owes you money. Maybe there's a rent reduction order from many, many years ago, as we found in lots and lots of buildings, etc. Right? So that's a defense. Another defense is conditions in your apartment, right? A warranty of habitability defense. And for a warranty of habitability defense, a tenant can go back 6 years. So let's say you lost your job and you couldn't pay April, May, June, and July, and August and September rent, right? But for the past 6 years or more, you've been dealing with a myriad of conditions in your apartment: mold, leaks, rodents, roaches, you know, defective appliances, etc., right? Any housing maintenance code violation. Potentially, right, if you go back 6 years and get an abatement over that time that you were paying the landlord the full rent, perhaps the amount that you're owed as far as an abatement, right, cancels out whatever it is that you potentially owe for the months that have accrued. It's an important defense. Other defenses, right? So harassment is a defense to a non-payment case. Have you been harassed by your landlord, right? We hear these stories all the time. Landlords knocking on doors or sending their, you know, henchmen or people to knock on folks' doors. You haven't paid the rent, that is classic harassment, and we should assert those defenses in these cases, right? Really what I'm saying is folks shouldn't feel like a sense of powerlessness just because they've fallen behind on the rent and the landlord is suing them. Yes, it's scary. Yes, it's nervous. Yes, you're going to want to avail yourselves of programs, one-shot deal. The CARES Act money has been exhausted, but it's also a situation in which you have rights and you can litigate against your landlord, right? You can assert different claims. Holdover actions are different, right? And the one thing, and it's that there's too many sort of different holdovers, so I'm going to sort of open this to the Q&A. But with the holdover actions, one thing we really want to sort of be careful about and focus on is unfortunately, there was a lot of death in the city, tragic time in the city. I talked to a landlord lawyer who recently, yesterday, who represents lots of federally subsidized buildings, and she told me that she had 70 holdover cases based on tenants who had died, and that's a big number. And people have rights to succession, right? Meaning, if you live in an apartment with someone who is your family, or with someone that you have a family-like relationship with, and I could talk about that a little more, then you absolutely have the right to succeed to that individual's tenancy. Immigration plays no role, right? There are some cases that immigration status is not something that's the court can inquire about, nor is immigration status something that should deny somebody the right to succeed to a rent stabilized apartment in New York, right? An undocumented individual can succeed to a rent stabilized apartment in the city. You know, and also there's been some amount of, besides the tragedy and the death, right? There's been some amount of movement out of the city. So potentially, right, the tenants of record, maybe they're older, maybe family members don't want them in the city and they're worried and they've moved them, you know, wherever, back home, you know, wherever they are. But there's still folks living in the apartment and the landlord maybe brings a case. Those folks potentially have the right to succeed to those tenancies. So in conclusion, I really want to stress, you know, that we have an eviction moratorium in place, right? Nobody can be evicted until October 1st. Anybody that's immediately at risk, and I think the number it's been published is about 14,000 households, right? Where there was what's called a judgment and a warrant that had been issued, and that would have had to have been issued prior to the pandemic, right? So if you were potentially sort of slated for an eviction sometime in mid-March or late March, right? You've sort of, you know, been shielded from that horrific act for now. Those folks are the most at risk, right? The folks that have fallen behind in rent due to these incredibly difficult times, you're not at immediate risk, right? I don't want to minimize sort of the, you know, what you're up against, but you're not at imminent risk of eviction, right? They have to start a court case. And the way the courts are operating now, that court case, even if you have no defense whatsoever, that court case will last several months. Finally, and this is the last thing I'll say, and I'll open it up, there is a an executive order law now. It's not a law that would allow people that fell behind in rent, if they can show that they were economically impacted by COVID, that the arrears that they owe the landlord would not be a possessory judgment. And what does that mean? So in a normal situation, in a non-payment case, you owe the landlord money. It's a case about money, and you owe the landlord money. But if you don't pay that money, you can be evicted, right? The catch is the payment is tied to the apartment. And what this law does is it says that, yeah, the tenant may owe the money, but that doesn't result in the tenant losing their apartment. So that's something else everybody has to be aware of. So with that, I'm going to stop. I talked too much. I said I was going to keep it brief, but that's sort of my little spiel, if you will, my little talk. And I want to open it up and sort of get questions and take it from there. Thank you.
Well, Jesse, this is great, but before we open it up, I think
Sure.
I'm going to ask you some questions just based on the calls that we get every day.
Absolutely.
In terms of the rights, we know that a lot of us who are falling behind on our rent, we feel like we have no rights. And I think it's important to point out that, one of the rights that they have, obviously, is the right to get an attorney, right?
Absolutely.
Two is the to lease renewal, the right to have a lease renewal. Just because they have not paid their rent does not mean that the landlord doesn't get to do the lease renewal. Are there any other rights that you can think of during the COVID-19 pandemic time that, it would probably, it keeps families up at night, but in reality, they really should just address it right off the bat. Those are the first two that I know that a lot of these questions have come up, is that, well, the landlord says they're not going to give me a lease because I haven't paid the rent. But can you talk on that a little bit?
Sure, I can. Actually, the landlord is obligated under law to issue a renewal lease to a tenant, regardless of whether or not they've paid the rent, regardless of whether even the landlord has started a case against the tenant, right? There is a legal obligation for landlords to issue renewal leases for any rent stabilized tenant. So that is absolute. And folks should not, folks, if people do not get renewal leases from their landlords, what you can do, and it's actually the only thing you really can do, is you can initiate a proceeding at the DHCR, right? And you can do that without going there. You could do that, you could print the forms out or fill them out online and send them in. And that's a failure to renew a lease. And that is absolutely a tenant's right. Another thing that's very, very important, Elsie, that to your point, that folks should realize about their rights is that tenants have the right to live in habitable apartments regardless if they're paying the rent, right? So oftentimes folks will say, yeah, the kitchen ceiling is leaking, or the kitchen faucet doesn't work, but I can't, the landlord said he's not doing it until I pay the rent, or I'm afraid to call the landlord because I haven't paid the rent. No, those don't go hand in hand. The landlord is legally obligated to remedy those conditions regardless, right? Regardless of whether or not tenants are paying the rent. And listen, the other thing I'll say too, and this is right in Elcia's wheelhouse, if you will, is, we've heard, right? And we know that throughout the pandemic, landlords have used it as an excuse, right? Not to upkeep their buildings, right? And not to make basic repairs, and, have cried poverty or nobody's paying the rent, that I'm not gonna, and have allowed, unsanitary conditions to fester, have allowed neglected repairs to go unheeded, etc. And the best way to address those, right, is to organize and to form tenants associations. And those become very, very, very powerful tools as far as leveraging some power against your landlord, right? And the solidarity that folks would have when they come together with their neighbors for a myriad of reasons, right? One of them actually for us is it allows people to pool resources, hire really good lawyers. But even if that's not what's going on, a united front, right, addressing the landlord is a very, very different thing than an individual tenant reaching out to a landlord. If you reach out on behalf of 20 of your neighbors, it's just a very, very different scenario.
Just say regarding the security deposits, as you remember, when we're in the trenches during the pandemic in April, March and April, the governor allowed landlords to take the security deposits. But what is the process? Like, I mean, we had some tenants that basically the landlord just decided to take the security deposit without asking them. And there are others that were asked, as would you like to use security? What exactly is our landlords supposed to have done in order to take the security deposits? And if you could also elaborate on the late fees, because I know we've also seen late fees on these rent statements.
Right. So with the security deposit, the way the law reads with the security deposit is that it has to be the request of the tenant, right? The landlord can't unilaterally apply the security deposit to a month's rent. Now, the tenant might want that, but the tenant actually has to go and affirmatively ask, right? So if your landlord has done that, you should write your landlord so you have something in writing to say that you improperly applied my security deposit to a month's rent when you shouldn't have, and that's how that should be addressed. I'm sorry. So what was the other question?
The late fees.
The late fees, yeah. So, right, there has not been, I'm not aware of there being any legislation or executive order that would address the late fees, but there might be, and if there is, I'll get back. There have been
the pandemic. The owners were not to collect
right.
late fees.
They were not to collect late fees, right? So that would be improper, and it's hard to, when you get the bill and you see them, again, it's hard to kind of get them to strike that, but folks should then know that they're not responsible for those, and they should absolutely not pay them, right? And then make sure, if you're actually being sued, right, that you're not being sued for anything other than the exact amount of the monthly rent and not a penny more, right? Because they'd like to play those games and throw them in and act as if they're some other month's rent that you paid and couch them as something different, right? Just because you owe the landlord, May, June, and July rent doesn't mean you owe them a penny more than that amount of money. And maybe you don't owe them that money either.
So what should tenants do when we've had some small landlords that they like to make personal visits to collect the rent, and they get verbally abusive? It's impacting the sanity, the health and safety of our children, especially when these landlords come knocking on the door. For any families or any person that has their landlord bang on their door for money, what should a tenant tell the landlord?
Thank you. Yes. So here's what people should tell their landlord. They should tell their landlord that they do not want them to speak to them except in writing, and that what they're doing is a form of tenant harassment, and that they will be reporting the harassment to the proper authorities, and hopefully that deters the landlord. Here's what everyone should do as well, right? When those incidents happen, to the extent that you can, right? Everybody now has a smartphone of some sort. People should record those, right? New York is a one-party recording state. You're absolutely within your rights to record any conversation with anybody without them knowing in New York State. You should record if you can. If you can't record afterwards, you should write an email to somebody, right, to document that, so you have something that's date stamp that we can prove when it happened, or keep a log, right? Because if you inform your landlord that is harassment and they continue, then the harassment laws, there's big holes in the law, and justice delayed is justice denied. And I understand things take time, but the harassment laws have been strengthened, and tenants really should avail themselves of going after landlords that harass. And really, right before the pandemic, there were a couple of really, really good cases, decisions where judges really slammed landlords who engaged in this behavior with significant abatements of rent, or penalties, if you will, that were awarded to tenants. So we really haven't begun as tenant advocates to explore the extent that we can use these anti-tenant harassment laws.
Mhm.
But it's certainly something all of us tenant advocates are very interested in seeing how far we can go, and really establishing sort of a new reality where landlords don't engage in this type of behavior, right? Again, this is not an equal power dynamic, and they might say, "Oh, I didn't do nothing. I just came to the door and knocked on the." But that's intimidation. And as Alcia said, your children are there. They don't need to be subjected to that. I mean, that is ugly, and they should be held accountable when they do that. So again, I'm not saying it's easy, but you got to sort of stand your ground, know your rights, inform your neighbors of their rights, and stand up. And I always say, sometimes you gotta like punch a bully back. You really just gotta stand in their face and say, "You are harassing me, and you have no right to harass me. If you cannot come and ask me for the rent again. Anything you want to communicate to me, you communicate to me in writing."
Okay.
And then,
Now that you said that, Jesse,
yeah,
not to interrupt you. So you said writing, that's a key word. Because what we've seen, especially in Queens and Brooklyn, landlords like to get really personal. So now they're doing texting, literally harassment emails and texts to the tenants saying, "No, I'm not gonna allow that. I need 4 months rent right now. I'll be at your door tomorrow." How should a tenant respond now that they have the landlord? Now they have proof, right? Now this is harassment. Now you put it in writing. What would be the key word that a tenant would respond to him, to that or her, that landlord, to stop the harassment and to also be able to use that later down the road on a harassment case?
right. So I think so a couple of things, right? So if people feel physically in danger, right, they can, I don't know if this is, but you could try to get an order of protection against your landlord, right? I mean, it's possible to do that. You can also file what's called an HP action. You can initiate a case against your landlord based on harassment. And, that could be an effective way to back your landlord off, right? They get served with court papers that state that what they're doing is illegal, and that they're being brought to court for that illegal behavior.
Mhm.
Look, this is not easy, and I'm not, I don't know if there's any real sort of magic bullet response to these types of bad actors. I'd also encourage folks, if they feel threatened to that extent, right? Maybe not, but maybe to reach out to their elected officials, and maybe their elected officials can make phone calls, right? Reach out to organizations for help. Maybe talk to your neighbors. They might be going through the exact same thing that you're going through, right? So these can be effective ways to sort of push back. But like I said, sometimes these folks, they're just thugs, right? And you gotta sort of, they only respond when they're, forced to, right? When you kind of sort of stand up to them and back them off, right? So, but yeah, maybe elected officials and elected officials by and large have been supportive and have been cognizant of sort of this pain that can be inflicted by just sort of your economic reality being tortured, right? It's really what it is, right? Because they know where you live, in your vulnerabilities. It's an awful, disgusting thing. And I think sort of potentially, large scale, and we'd be interested in, if there's groups of folks, we've been interested in doing this sort of, absent any fees, and sort of as in a way to sort of push this along. So folks should be ready to do that, right? And ready to kind of go after your landlord. And because you haven't paid the rent, you can initiate a harassment case, and you can go after your landlord for that type of behavior.
That's excellent. And I think, we've seen a lot of that, especially within the Latino community, that landlords are taking the opportunity to reach out either in person or via text as late as 10, 11 p.m. at night, which is a time that we all should be resting, right? Or, we're putting our kids to bed, to bring that level of anxiety. And I think it's important that our audience understands that we understand that a lot of us lost income. We understand that we're behind our rents, but we also have rights. And landlords have responsibilities that they need to adhere to. So
Absolutely.
in the event, that they start blast texting, sending emails, sending text messages, use as an opportunity to say, you know what, I'm going to use this against you in court. But don't engage. Go back to the part in writing. Send me, I'll see you in court. Send me some documents in writing, but stop texting me, stop calling me, or stop knocking on my door. I think, that for tenants that are behind on their rent and they're looking for resources to pay the rent, they can also start like you mentioned at the beginning of the call, which is start getting your rent registration history. Let's find out if the rent that you actually been paying is actually legal. Because there is an opportunity, there might be, What do you think, Jesse?
Absolutely. No, everybody should do that. Everybody should, affirmatively do that. Whether you owe rent or not, get your rent registration history from the DHCR, right? I mean, again, we just secured this $8 million settlement. We do rent overcharge cases for folks in the city all the time, recouping tens of thousands and hundreds of thousands of dollars for tenants. Folks really, really should investigate the histories of their apartments to see if there's something there, right? I mean, it doesn't hurt, and it sure could be something that could be advantageous. So folks should do that.
I like to tell folks that once the Ramon Hernandez case, which is a case that we had back in 2014, Ramon had actually, his landlord was harassing him. And he went and got the rent registration history, which is what we're advising everyone that's on the call today. And when Ramon came back, he had a job at that time. And when he came back and he brought us the rent registration history, we found out that his rent was actually frozen to $350. And it had been frozen since before he moved in. And when he moved in, he was actually paying $1,500. In the process of us submitting the paperwork, Ramon had an injury at his job that would not allow him to work. And we filed the rent overcharge application for him. Because it was pretty much set. If there's just a rent reduction to your apartment, it doesn't matter who the landlord was, it doesn't matter who the tenant is. At the end of the day, if the rent was not restored, the apartment continues with the rent registration frozen. I mean, the rent frozen. Make a long story short, Mr. Ramon got himself $129,000 in rent reimbursement. And people look at it like going, how is that even possible? But it is possible. But it took for him to be harassed by the landlord, for him to start getting to the point of looking into whether or not his rent was legal, because clearly he could not pay the rent and he was upset. So I think we should all put our energy in not feeling sorry for ourselves, but really looking for tools on who can defend ourselves. And for those folks that, and we're going to talk about this later on, but for those folks that are looking for rent arrears, there are resources there, and there will be more resources when the courts open on October 1st. So do you have anything else to add, Jesse, or should we go and do a Q&A now?
Let's do the Q&A.
Well, let me patch it over to Daniel and Robert then.
All right, fantastic. We do have several questions, and I hope that based on some of these questions that we're reading out, we'll have even more questions that are coming off the heels of those. So we have one of our first ones. Is there any progress from DHCR response to the Regina Metro ruling? As a follow-up to that one, it was, how does your overcharge win impact the Regina? Congrats on that win.
Okay, so we're gonna go straight into the weeds, right, of rent overcharge, litigation. So, just if I can just sort of say this as simply as I can, Regina Metro was a case that went all the way up to the Court of Appeals, right? So, for about 10 years, there was a bunch of back and forth throughout the courts and the appellate courts about how rent overcharge damages should be calculated in situations in which an owner received a tax abatement, right? In this case, it was a J51 tax abatement. There's other tax abatements that owners get that require them to have their apartments be rent stabilized, like 421A, 421G, but this was the J51. And the Regina decision was horrendous, right? I mean, I'll just say it that way. It was a devastating blow to tenants because what it did is it said that the retroactive application of the Housing Stability and Tenant Protection Act was unconstitutional. This was the first time that the Court of Appeals struck down a piece of legislation on U.S. constitutional grounds since 1936, when they ruled against some child safety, child labor, law thing. So it was an incredible decision. And I'm going to be cynical and maybe get myself into trouble, but there's something about how this happened that maybe the real estate industry got in the ear of, and they whined and cried about how devastating the HSTPA, that's the new law in 2019, when progressives and Democrats took both houses up in Albany, that somehow, some way, they sort of had to do something to kind of recalibrate things in favor of the landlords, as if they needed that. So there's no way to sugarcoat this. The Regina Metro decision is terrible as far as the rent overcharge world. And really what it does is it limits what's called the look back period to 4 years before you file a complaint. But there's exceptions, right? Meaning if you can show that the landlord engaged in fraud, you can go back further. If it has to do with whether or not your apartment was destabilized, you can go back further. When it has to do with a rent reduction order, as Alcia, illustrated in that example for Mr. Hernandez, right? That you can go back further, right? So it doesn't eliminate the right of a tenant to explore their history, but it did sort of give the landlords a real win. How did it affect the case that we did? It didn't because we were working on a settlement prior to Regina, and while it impacted it somewhat, we didn't have to sort of take the full brunt of that decision. So I'll just sort of, that's the best way I could put it.
Yeah, the last question from this individual. My landlord seems open to renegotiating my super high over 3K rent for my rent stabilized apartment. Caveats?
No caveats. Here's the thing that I've heard this and I've seen this, right? So it's a different reality in New York at the moment, right? How long this lasts, what it means, I think we're all sort of seeing in real time. But there is some ability, I think, for tenants, even rent stabilized tenants, to possibly negotiate with their landlords to reduce the rents. Here's the kicker though, right? Here's the real issue, is that I don't think landlords are going to do any sort of reduction in rent out of the goodness of their heart, right? They're not going to do it because they feel some sort of sense of compassion. They're going to do it because they see some risk. And I think the question, right, is important because it's a $3,000 rent. And I think in that situation, what the landlord is looking at, whereas pre-COVID, there'd be no discussion and they'd be so happy to get rid of a stabilized tenant. But now I think what's going on in some situations is landlords are saying, I have a tenant who is paying. If that tenant leaves, right, I might have a vacant apartment and be getting no rent for that unit. So if the landlord thinks that the tenant might vacate and that becomes the tenant's leverage, then the landlord may be open to negotiating a lower rent, right? But it comes from creating that leverage, and that is not something that is universal for all stabilized tenants or all renters. I want to be very clear about that. I think that scenario plays out more typically, as the questioners put it, when you have a somewhat of a higher rent and you have a landlord that just is scared, if you will, right, that if that individual left, that they'll be sitting there with a vacant apartment and not be able to re-rent it.
Mm-hmm.
When will we find out if we're going to get help after filling out the forms for the COVID rent recovery checks? I made the deadline and haven't heard anything yet.
I think, unfortunately, and Alcia might be better equipped to answer this, I think the money is gone. Is that true, Alcia?
It's gone, but I know that the agency is still in progress. I mean, they're even asking some landlords for W-9 forms.
Okay.
I think we should give it another week. And if you don't hear anything from your landlord, let's say for the September, let's say it's the September rent. If you don't hear anything from the landlord, reach out to our office and we could, we could follow up on your case individually with the state. But I think, it's worth waiting for the September 1st rent statements to come in. Maybe the landlord is hoping that you will come up with another check and to paying the rent, and your rent might have already been paid. We don't know. So just reach out to us on September 1st to see if we could follow up individually in the event that the DACR did not pay the rent on your behalf. But I personally have not heard that any tenant has actually gotten notification saying we paid your rent. They've actually heard it from the landlord saying, hey, we got a check for you, that kind of deal.
We do have some questions in Spanish, and if you would like to hear the interpretation of those questions into English, be sure to jump onto the English channel. And I'm going to read one of these questions now in Spanish. ¿Por qué los dueños están enojados? ¿A ellos les afecta el atraso de pago de renta? ¿Ellos no tienen ayuda?
I'll let you answer that, Jesse.
Sure. So, listen, I'm not here to like do any landlord bidding or anything like that. So it's kind of difficult for me. Why are they angry? I mean, I think they're generally angry. Just that's their disposition. But seriously, there is some amount of percentage of their tenants, I think broadly, right, that they can't pay the rent, right, through no fault of their own. And what they're doing is they're trying to get relief, and honestly, there should be something that sort of benefits everybody, right? Like maybe their property tax bills or their water bills or their whatever expenses, right? Because there are expenses involved with running a multiple dwelling in Manhattan. It's just a reality, right? It doesn't, right? It's not like the landlord, again, this is hard for me, but it's not like the landlord, the rent roll is all profit, right? It's not all profit. They, maybe they have a super or a porter that they're paying. They certainly have property taxes, And I think what they're saying is like, we can't pay our bills either, right? If we have 30% of our building that the rent's not being paid, our margins aren't sufficient to allow us to continue operating. And you're gonna, you hear it all the time, you get the, again, but it's hard for me, the buildings are gonna deteriorate, the usual, sort of stuff that, cry me a river kind of.
I think every landlord should have a reserve account.
I agree. Yeah, I mean, look, and the other thing too is there's no way to sort of show they have infinitely more resources than tenants, right? They have a building. They have a building in New York City somewhere that's worth millions of dollars, right? So there's financing, there's things they could do, right? So to sort of say that, tenants and landlords are in this, it's just a false narrative, and we should reject that. It's just not the reality. It's just not true. But I'm more saying it so folks can kind of hear what we hear and can digest that. But in no way is that sort of a fair. It's just not. It's just not something that people should really pay any attention to or give any credence to. It's just not something that's legitimate.
Yeah, I think tenants need to understand that landlords have two bank accounts. One is for the day-to-day of the building, to maintain the building, pay the super, pay, expenses. And then they have what is called a reserve account. And this is like our savings, except that our savings don't get into the millions like they have.
That's right.
So I'm sure that they will be able to survive, at least during, from March till now. Unlike, I don't think at no point in time, any of our families should go hungry just so they could pay the rent. I don't think any of our seniors should, go not buy their medicine or food to pay the rent. I think, that as long as you understand as a tenant that you cannot be evicted right now, as of October 1st, you can't go to court. You're not going to be able to see any judge right before October 1st. It gives you an opportunity to find this money, the different resources, but do not believe the hype. Do not believe that just the landlord is, oh, poor little me, I have no money, I'm going to maintain. That's his problem. The same way that you have to go find money to pay the rent, he has to find money. If in fact he doesn't have money, which I highly doubt, because as many of you that have known me on this call know that I always tell people don't plan to fail, they fail to plan. And we didn't plan the pandemic, but landlords plan bad days because they're managing a building. It's a business. Next question.
Sure, we have a question in Spanish, and I'm going to get that set up. One moment, please. Buenas noches, mi nombre es Claudia. Yo quería preguntar si ustedes me podrían ayudar. Yo debo más de $7,000 en renta, pero el landlord no me ha enviado ningún papel de corte y yo he intentado con Catholic Charity y Home Base, pero ni uno me ha podido ayudar. Mi esposo ya empezó a trabajar este mes, pero él estuvo sin trabajo durante la pandemia. Traté de aplicar para el One Shot Deal, pero me lo negaron porque no tenía ingresos en ese momento. ¿Puedo aplicar otra vez ahora que está trabajando mi esposo?
Absolutely. Yes, you can apply, but I would be interested to find out more about your case for the one-shot deal. Especially if there are children, you should not have been denied. So if you could reach out to our office on Monday, we would need to have your case number and your social security number so we could reach out to the heads of HRA and find out what happened. But yes, you can reapply, and I recommend that you reapply over the weekend. So by the time that we're reaching out to the agency on your behalf, we'll be able to start all over again and expedite your case.
Do you know of any holdover cases started against rent-regulated tenants due to non-primary residence reasons? If not, do you believe landlords are likely to start those cases against tenants who have left New York City because of the pandemic?
Yeah, really good question, right? So just as by background for folks, one of the ways a rent stabilized tenant can be evicted is if they don't maintain their New York City rent stabilized apartment as their primary residence. Here's what the bottom line here is. Myself and all of the folks at my firm collectively, we probably have hundreds of years of practice. We've done thousands of non-primary residency cases collectively. None of us think that anybody, particularly if you're at risk, right? But even anybody who decided to shelter in place somewhere other than New York City should feel any risk about that time being accepted by a court as, evidence of their non-primary residency in New York. Now, understand though what I'm saying. That's if you left New York, right, sometime in mid-March or early March or April, right, and it's becoming less sort of defined now, where we have one of the lower rates of transmission in the country, but potentially still continuing, right, because living in a apartment building in New York, right, might present risk that living in a house somewhere, right, or quarantining with family and all those other related issues. Nobody, and I don't think that any landlord will be successful in evicting someone based on non-primary residency because they decided to shelter somewhere other than their apartment during the crisis. So I don't think there's really any risk, right? The law already recognizes some exceptions to primary residency. You have your mom, she's sick, you go down to Florida to take care of her for 6 months. You don't lose your rent stabilized apartment because you want to spend time with your mom when she's ill. You enroll in college or graduate school and you're out of, you don't lose your rent stabilized apartment. We all feel very strongly this will be exactly that scenario if landlords indeed proceed on that sort of ridiculous claim. So, yeah.
How would you find out if there was a past rent reduction order, would it show up on the rent registration, or would a tenant need to submit a FOIL, F-O-I-L request?
Well, actually, this is what a rent registration history, can folks see, right? This is what it kind of looks like, right? A rent registration history. If you go to the last page, of the history, right here, if you see anything that says related cases, and you see a number next to it, and there's an S at the end of the number, that is a service complaint, which would most likely be a rent registration, a rent reduction, unless you submitted a current complaint. But it is on the last page of the rent registration history. And for those folks, you guys can just call it in and order it. They'll mail it to you free of charge. But when you do ask for it, make sure that you ask for the entire history, which is from 1984 to present. And if you want to figure out if there is a rent reduction before you will help, you analyze whether or not your name is on the rent registration history, you just go all the way to the last page. I think it's important to point out also that the landlord is mandated to have your name on that rent registration history in order to take you to court. Am I right, Jesse, on that?
Yes, that's exactly right. You need to,
Be registered in this document.
yeah, and if you show any lawyer or anybody that does this type of work, your history, they'll be able to assess, as Alcia just did, whether or not there's a rent reduction order, potential rent reduction order that impacts your case. So yeah, that's exactly what you should do.
Wonderful.
Do a lot of these answers apply to New Jersey laws as well?
No, this is all of New York. I'm sorry.
Yeah, I can't speak to New Jersey. I'm just speaking to New York. I got to make that clear. Yeah, I'm not. Housing law in general is very, very, very much specific to the locality, right? So even to some extent, though it's changed a little bit, even to some extent, like if you lived in Yonkers or you lived in Nassau, right? It could even be different than in New York City. So it's very, very, very local. So certainly nothing that we're talking about would apply to New Jersey. That we can say.
Good evening. I received a letter taped at the entrance of the building. What happens now that I did not call housing court? Your landlord has started an eviction non-payment case against you for rent. The landlord claims you owe. You have a right to a trial, but you must answer the petition by going to the landlord-tenant clerks. You must do this within 10 days after these papers were given to you in person. If petition not answered within 10 days, a judgment may be entered against you, eviction.
Yeah, this individual should call the clerk's office Monday and explain if it was taped to where was it taped? To the apartment door or whatever it is, they should say that they just got it, or they weren't, they should explain they weren't aware, they didn't, although maybe it says it on the papers, but they should call the clerk on Monday. I think it'll be okay. They should call the clerk on Monday.
We have a question in Spanish. Now. Entonces, cuando la moratoria termine, ¿tengo que pagar todo lo atrasado en alquiler o a partir de allí me dan un tiempo para pagar?
Yeah, you will be given some time to pay it if you work out a deal with your landlord to do so. Also, as I pointed out earlier, potentially, right, or likely, the money that you owe that accrued during the pandemic, right? So starting in April or March, those monies can't lead to your eviction, right? So those are two important things you need to consider. But I think overall, judges, and I'm hopeful, will be sympathetic to the economic devastation that New Yorkers experienced as a result of COVID, and will allow tenants sufficient time to pay back money. And I do think that is likely to play out but availing yourself of the resources we've talked about during this webinar, that's also important. And that also could lead to a more favorable settlement that provides you ample time to pay back the money. You could work out a payment plan. These are all things that are possible, right? I mean, meaning, pay back some portion of what you owe every month for the next 7 or 8 months, right? These are all possibilities.
Buenas noches a todos los panelistas. Mi pregunta es que la casa donde vivo con mi familia ahora es el dueño, el banco. No hemos estado pagando desde febrero porque nos dio un inquilino un documento diciendo que debemos salir porque teníamos 3 meses para salir de la casa en marzo, pero he conseguido arriendo, pero me piden que pague de 3 meses, pero no tengo, me quedé sin trabajo, ¿qué debo hacer? La dueña de la casa viene molesta, tuve que llamar a una amiga, ella se hizo pasar por abogada, ahí se fue de la casa, me dijo que era del banco, le pedí que me muestre la identificación, pero no tuvo nada, sí que me dio miedo que me mande sacando de la casa con mis hijos que son menores de edad y mi papá es de tercera edad. ¿A qué número debo llamar para pedir el registro? Por favor, ayúdeme. Gracias a todos.
Okay, so Elcia might be able to help as far as some of the answers, but what I can say is, and we got to make this clear, if you live in a 2-family house or a private house or a 3-family house, those apartments are not subject to rent stabilization, right? So that housing, and there could be an exception, right? It could be a tax abatement, but by and large, that housing will not be subject to rent stabilization. Rent registration history is only applicable to rent stabilized apartments. It's not applicable to any other housing. So likely that's not going to be something that's going to give you any relief in this situation. Elcia might be able to say like a number that maybe this individual can call, and then we can maybe try to sort of individual give her some advice. There's a lot going on there. Maybe that's what makes most sense. You're muted.
I'm sorry, I just noticed I just muted myself. I would recommend for the person who's asking this question to contact our office on Monday after 11 a.m. just so that we could get an understanding as to how many agencies we can get involved to get you guys some help. So our phone number, if you don't have it, it's 212-491-2541. And call and ask to speak with me, and we'll see how we can help you. The number to our office is 212-491-2541.
My super's wife had me arrested and fired from my job. Also, she had an order of protection against me, and I spent the next 2 years in silence in the apartment. I believe she did it to financially disable me from paying rent. How do I watch my back in the future?
I'm sorry. What's the question again?
My super's wife had me arrested and fired from my job. She also had an order of protection against me, and I spent the next 2 years in silence in the apartment. I honestly believe she did it to financially disable me from paying rent. How do I watch my back in the future?
I think that the person should reach out to the elected official. I wouldn't even know what to say.
I was informed by an organization that I should not appear or call because this will push my case at first line once courts reopen. I'm confused now that I heard from this call that I should have called housing court.
Yeah, that's a good question. I've heard that too. And I think there's some debate here about what you should do. So, you know, look, these are different times and these are new, right? This is a new situation for all of us, right? For advocates, for lawyers, for tenants. So here's what I can say, right? I can say as a lawyer, right? Ethically, my ethical responsibility as a lawyer is a little different. I can't tell anybody as a lawyer, right, as an officer of the court, to purposefully delay litigation, right? I can't give that advice, right? So again, I'm not saying that that might not be the best approach, right? And the individual, and if they're still on the line about the holdover, I don't want anybody to be scared. I don't think anything is going to happen to anybody who doesn't answer their case, right? I don't think that. But to say that it just won't, anybody that says, if you don't answer court papers, right, or purposely ignore them, right, consciously ignore them, that is somehow the right thing to do, that I don't agree with, right? Again, I don't know, right? It's a strategic decision, and that there's validity there, right? There is a valid argument to be made. I acknowledge that by not responding, then your case sort of ends up in the bin, ends up in the mix, ends up, right? But I will say this. A tenant can be defaulted, and that law hasn't changed, right? There's been no change to what constitutes a default. The default is if you're properly served with court papers and you fail to appear, right? That's what a default is. Now, fail to appear in this environment is a very fluid term. So, you know, again, but here's the problem with that approach, right? And again, we're debating this and there's some discussion. What do you say if you're under oath somewhere and says, did you receive these papers? What are you going to say? No, I didn't receive them. And when you received these papers, when you read it, did you understand that it said that you should, and then what did you do? And if you're going to, you know, perjure yourself or not, are you going to say, I decided I wasn't going to call because I was told that was the best thing to do to delay? Therein lies some of the problem, right? So I don't know if that would be sound advice to say, ignore it. Don't, you know, worry about it. Do I think ultimately that might prove to be the correct strategy? I do, but I can't in good conscience, particularly as an attorney, tell you that the best approach, if served with court papers, is to simply do nothing and ignore it. I think that could potentially be problematic and could be dangerous, right? I really do, because exactly for that reason that I outlined, right? What do you do in the event that 3 months from now, the court says, what happened? And put you in a position where you're either on a Zoom call like this, or maybe in person if the numbers continue, that are you going to lie to the judge, right? Are you going to lie in court under oath and say something other than the truth, right? Which would be, I decided and I made a decision to purposely not do this because I thought it would benefit my case and not have the case be heard. That's trouble. That's trouble. So I worry about that, and I can't say that, I can't endorse that as a strategy, right? So, but but at the same time, make sure everybody hears what I'm saying. I'm not saying in any way that could not possibly be an effective way to handle a particular case. It very well might be. So therein lies the problem, and therein lies the fluidity that we're all, I think Alcia said right at the beginning of the call an hour or so ago, things change every day. And it might very well be in the next days or weeks, we're getting information that people that don't answer, their cases go to the bottom of the barrel. Maybe that's what happens. And maybe then we'll feel more comfortable sort of off the record, right? Providing some of that sort of strategic advice. But I certainly can't, right? Because as an officer of the court, as an attorney, I'm actually ethically not allowed to advise someone to purposely, consciously avoid litigation, right? That's not something that I can do. And certainly, right, and I've done this, and I did this, you know, for some, you know, people just this week. I started cases against landlords, right? People who are displaced because of a fire and want to go in. I would hate the landlord to be served at their office with my papers and decide, you know what, the best strategy here is for me to ignore this, and this poor, you know, individual is out of her home because of a fire, and we're trying to get the landlord to do the repairs to get her back, and the landlord has decided, I'm going to ignore this and strategically maybe put this at the bottom, right? So that's a difficult spot, and I'm not really sure sort of what to do. But again, I'm not saying it's not good advice. I'm just saying it might not be the best advice.
I live in rent stabilized. I was awarded rent reduction retroactive to 2018. In this order, another prior order was mentioned that is still in effect. This order was in effect before I moved in the apartment in 1997. Items in the prior order was never fixed. When I moved in, how much should I deduct from my rent? I have since filed an overcharge and that decision is pending. I have continued to pay the full rent that I am charged. Generally, what are the next steps in this type of case?
This is a case in which you should get in contact with Elsia, and it very well be a case that I'd be interested in sort of looking at and taking. Those are very compelling facts, and it's just, there's just too many variables. These are complicated cases, right? Rent overcharge complaints are nuanced, difficult sort of factual legal cases. So it's not something I think is readily addressed in this sort of forum, but I do encourage you, please reach out to Elsia, and Elsia could maybe put you in contact with me. Certainly that sounds like very, very compelling facts, something very, very sort of potentially, big overcharge damages.
Mhm.
Si algún inquilino tuviera cita en corte, ¿ustedes pueden acompañar al inquilino?
Well, I'm going to answer that first. Before, you guys need to understand that Mr. Jesse Gribbin is a private attorney. Before we solicit the assistance of Mr. Gribbin, I think the first thing we need to look is to see if you can actually have a free attorney through the right to counsel. So as a follow-up to this call, we're going to send an email to all of the participants with a list of, with the zip codes of where you could actually secure an attorney. And if you aren't able to secure an attorney, then you could reach out to our organization. We'll see what we can do. But I'm certain that you'll be able to have an attorney because of these times that we're living in right now, be able to accompany you in court.
Is it legal for an apartment to be held vacant, for example, more than 2 years without being rented?
There's nothing illegal about landlords warehousing apartments. It's something that potentially tenant advocates, though, will seek to address as a legislative fix. But currently, there is no law against landlords leaving apartments vacant. But again, it's an issue I think tenant advocates acknowledge and do want to address. So yeah, so that's the answer.
Are landlords allowed to move ahead with MCIs?
Yes, landlords are allowed to move ahead with MCIs. I've spoken to several groups of folks confronting MCIs now. Landlords, not only are they allowed to, landlords are throughout the city moving forward with MCI applications. If folks get MCI applications, that you need to talk to your neighbors. That's a collective effort. That's not those are building-wide increases. They can be substantial and they can be fought against. You need to talk to your neighbors if you get an MCI application. You should not ignore it. You should answer it. You should potentially pool resources, hire lawyers. Yeah, those can be problematic, right? People sleep on them, if you will, and they end up getting rent increases. Again, the new law helps in that they can only increase the rent 2%. But what landlords do, and we've seen this now a lot, they used to do these like massive MCIs, right? Where they put a lot of things, the elevator, the boiler, the facade work in one great MCI because they could get, up to 6%. Now they can only get 2%. But we see landlords now putting in multiple MCIs. They'll put in an MCI for the elevator. They'll put in an MCI for the pointing. They'll put in it. So tenants are getting MCIs that, repeatedly again and again and again. These are things that you have to kind of push back on. So if you get an MCI application, you should really, you could reach out. You should reach out to me. We could talk a little bit about sort of what you need to do to get your tenant association together and move forward and challenge that.
I believe we have a related question to that in Spanish, which I'll read now. ¿por qué después de la pandemia mi landlord está cobrando $4 más en el bill y un cargo MCI que no sé de qué es?
Yeah, I'd have to see the bill, and I'd have to see, but the MCI increases are real, right? They're not, so, again, I'd have to know if the landlord got approved for an MCI and they got an MCI. MCI stands for Major Capital Improvement. It's when the landlord, the policy behind it is to encourage landlords to invest in their buildings and replace antiquated systems, the boiler, the elevator, renovate the lobby, right? New piping, there's there's a lot of stuff that can qualify, new windows. And when they do that, they seek to offset the cost on the stabilized tenants, right? So it's problematic to begin with, the whole concept, but it certainly is something landlords do, and they do often. So I'd have to look at that bill to sort of say what it is. Other questions?
Forgot about that muted mic there. Sorry about that.
No,
Can I ask Mr. Gribben to please repeat the exceptions to the 4-year look back in overcharge cases, fraud, and what else is deemed a reason for going forward with this case?
Okay, so the fraud is the big exception, right? A fraudulent scheme to deregulate the apartment. Fraud is not easy to prove, but we prove it all the time, right? So fraud is the big one. The other one that jumps at me is when there's a rent reduction order, right? Rent reduction, or LC is talking about rent reduction orders that happened in the 90s, happened 20 years ago. There's no ability for landlords to say, oh, that happened more than 4 years ago, and therefore it's not applicable, right? So if there's a rent reduction order, you can look back to whenever that rent reduction order was, whether it was 10 years ago, 20 years ago, 30 years ago, it doesn't matter. And then the last one is if you're living in an apartment that the landlord says is not rent stabilized, and you get your rent registration history for that apartment, and you see that your apartment was deregulated back, let's say in 2000, you can look back to 2000. You can always look back to the event that led to the deregulation of the apartment, even if it was more than 4 years ago. So those are the 3 major exceptions to the 4-year rule: rent reduction order, fraud, and if you're living in a deregulated apartment, you can always look back to whenever the landlord deregulated your apartment.
One follow-up question. My building was sold. The new landlord is the one open to negotiation. He owns multiple properties in the city. My former attorney, who got me absolutely nowhere, said if vacancy rate in New York City is above 5%, then rent stabilization is thrown out. Is that really the case with over 20,000 empty apartments? Has that already happened? Am I in an okay position vis-a-vis the new landlord? Can he take away my rent stabilization status?
Yeah, I think before Jesse, I think that it's very we're not in a position to give you advice on a specific case, especially if you had an attorney. I think this is more of a separate conversation, but I would not allow Jesse to just answer these questions because without really looking at the case.
Yeah, it's hard. Yeah, it's hard for me to do that. But there is a 5% vacancy, sort of requirement for rent stabilization. But your individual landlord can't unilaterally decide that the vacancy rate increased over 5% and deregulate your apartment. Trust me, if that's where this is headed, which, look, we should be on the lookout for that. That's everybody. That's million rent stabilized tenants in the city. That's a huge fight. That will be front page of every newspaper and a big, big battle. That's not something you need to worry about for your individual apartment. That's a huge, major, again, there's a million plus rent stabilized tenants in the city. And, so this is not something that you need to it's not you and your individual landlord involved in a battle about whether rent stabilization applies anymore. That's certainly not the case.
Mm-hmm. Well, Jesse, you've been terrific, and you've been very generous with your time. I really
Thank
thank
you.
you. I mean, my gosh, gracias, really.
No, thank you, everybody. I really do. I understand everybody. A lot of folks are hurting. A lot of folks are, trying to get information to give to their families, to their neighbors, and just a lot of respect to everybody and what everybody's doing.
Yeah, I think, Jesse, and things change so quickly in court. Maybe we could have you again when something changes again. I'm sure well before October 1st.
Yeah, I love doing this, Alcia. So I'll be glad to come back anytime. And I appreciate you extending me the opportunity to speak to people. I do.
I know, for a lot of the folks that are on the phone with us, on the webinar with us, and then I saw one of the comments of someone that clearly is very frustrated because they're calling our office and we're not able to answer the phones. And I'm going to explain why. Is that we are working remotely, and when you call Palante, it automatically goes to our phones. But we literally, at the beginning of the call, as I mentioned, I would take from 10:30 a.m. to 9 p.m. So if you do not get a voicemail, it's because all of our phone lines are busy and we're actually helping people. Unlike the larger groups that have a lot of money, that have the money to pay for an answering service to answer your phones, we don't have that. But what we do have is, subject matter experts, people that are very passionate that will come over and help you, whether it be on a Friday night at 8:30. So if you call and you can't get a live body, just keep on calling. But if you want to look at the alternate way, you could just send us an email. If you send an email to palanteharlem.org, we will be able to, and you'll probably get me to respond directly to your emails because I am monitoring emails. But we're doing as best as we can in terms of answering every call that comes in. And again, we're not the large nonprofits that have the ability to have phone service attendants. We are doing the work ourselves, and we're continuing with our cases. So going back to what from what we were talking at the beginning of the call, there's specific numbers that I want you guys to have, and specific email addresses that and websites that you should have. So if you are having an issue applying for a one-shot deal, whether it's that you cannot do the application online, whether you need to talk to someone, this is the phone number where you could actually speak to someone at the Human Resources Administration. And the Human Resources Administration, they're the folks that give you food stamps, which are called SNAPs. They can give you money for shelter. They can give you money for for expenditures. But they also help you with the with rent arrears, which is what called one-shot deals. When you apply online, which I recommend you apply online, you must request a one-shot deal. Otherwise, they're not going to entertain helping paying your back rent when you do apply. For the rent registration histories, you could call it in, or you could also email it, but we prefer that you call it in to get a warm body. At the Manhattan office at DHCR, they're located at 163 West 125th Street at the Adam Clayton Powell building. But to go there and visit someone, if you want to get a copy of your rent registration history in person, you have to make an appointment. But you could also, again, order it over the phone, this very same number, which is the 212-961-8930 number. If you are a resident from Manhattan, in Harlem, meaning East Harlem, Central Harlem, West Harlem, Washington Heights, Morningside, you can apply to Palante for our COVID rent relief grant. What we mentioned in the beginning of the call, this is a grant that we're putting towards your rent. We pay directly to the landlord. And each grant, if you qualify, each grant is $1,000 that we will pay towards your rent. And we have been able to assist a lot of families like that. It's not the entire rent. It's not, the state rent relief grant, but it's $1,000 more than we all had before. And then lastly, if you're looking to get PPE, if you're looking to get masks, please email our organization. We're going to open our doors again to do a distribution of masks and face coverings. And we would like to be able to call you so that you could pick up a pack of 50 masks or face coverings for you and your family. But we request that you please email us at palanteharlem.org. That's the email address that you see on the screen.